In this guide we highlight some of the difficulties brought to our attention by consumers with e-commerce. We also look at some of the solutions. Overall, our objective is the creation of a single global forum for the resolution of consumer disputes. For easy understanding, as I proceed, I will use rhetorical questions for everyone watching this presentation. First off, easy question: how are our legal systems organised? There's a traditional division of powers between the legislature, executive and judiciary. Legislature in the UK is Parliament, who enact the laws. The executive carry out the will of Parliament and the judiciary apply the law. Now times this by 193, which is the number of countries in the world, and you get approximately 193 jurisdictions over the internet. Even without the internet, people around the world have long realised we can't live in isolation. So the traditional model of a nation state is crisscrossed by international treaty obligations. One of the well-known ones is the United Nations, but there are others as well, such as the EU. The advent of the internet has done nothing more than land another nail in the coffin of a nation state. So regardless of what we hear, we actually live in a global village. What we're concerned with is commerce within this little global village. What is e-commerce? E-commerce is any transaction made over the internet. The internet can be accessed anywhere by anyone at any time. So an Eskimo can order an ice cream online. A person in Siberia can, for example, buy a mink coat from an online fashion store in New York if he wanted to. So when these transactions take place, whose law apply? Well, the answer is there's no law of the internet. This is down to the parties themselves. This is an area of private law which, to me and you, is known as contract. The closest we have to the law of the internet is an international convention, which is known as the United Nations Convention on the Use of Electronic Communications in International Contracts, or shorten that down, UNICITRAL. Briefly, private law will always take precedence over the convention. So if an action is started in the courts in the UK, it's UK private law that applies, not the convention. And there's a practical reason for that, and that is we don't have a world court which has jurisdiction over the internet. This is still down to nation states themselves. Hence, that's why we have the nation states' own legal system taking precedence over the convention. So if we get down to the nitty-gritty of a contract, how is a contract made? A contract is made whenever a party agrees to trade something for something else. That's easy. This is usually goods and services in exchange for value. To you and me, that is money in its simplest form. So when is a contract made over the internet? It's made like it's made anywhere else. It's when an offer is accepted. The questions start getting a little bit more technical. Who makes an offer? Well, surprisingly, it's not the trader. At common law, the trader is not making an offer. He is merely providing an invitation to treat. And this is established case law going back before the advent of the internet. I've got two cases: Fisher and Bell, 1961, goods in a shop window, invitation to treat. And then we've got another case in 1952, goods on a supermarket shelf, Pharmaceutical Society of Great Britain versus Boots Cash Chemists. Again, that was an invitation to treat. So when does acceptance occur? An offer is made when the consumer clicks the submit order or pay button on his screen. So acceptance occurs when the trader enters into further communication with the consumer. So the trader may do this by sending an email confirmation or an order number. So just to give you an example of why this is important. So we have a recent case involving Argos. A colour television was advertised at £29.90. What had happened is someone had misplaced the decimal point. It should have been 299, but someone by mistake had put £29.90. So what happened was Argos were entitled to refuse to accept the order. The advertisement at $29.90 was an invitation to treat. Simply purchasing or submitting the payment button, that was only an invitation to treat. It wasn't acceptance of an offer. Okay, so what part is played in terms and conditions? This becomes relevant once we have a contract. Once you have a contract, the question is whose terms and conditions apply. The answer is invariably it's the trader, and we get there by not only looking at the mechanics of the transaction itself, but the case law, which we have. We have a recent case in 2015, didn't directly involve a transaction over the internet, but I think there were two commercial parties. So where a party makes an offer on its conditions and the second party accepts that offer on its conditions, and without more, performance follows, assuming that each party's conditions have been reasonably drawn to the attention of the other, it's the second party's terms and conditions whose terms and conditions will apply to the contract. It merely confirms the situation that existed previously, prior to 2015. The last party sending terms and conditions before performance is affected is the party whose terms and conditions apply. In the situation that we're concerned with here, trader versus consumer, it's the trader's terms and conditions apply, because what we have is the trader making what we call an invitation to treat. The payment or the submit is merely an invitation to treat by the consumer, and then we have acceptance by the trader who does something further by some form of performance. So this means when the trader accepts the consumer's offer, it's the trader who does so on his terms and conditions. So what does this mean for real life situations? Well, it doesn't sound good for consumers. In every case that I'll refer to below, it's the trader's terms and conditions which apply. More often than not, they have a jurisdiction clause outside the place of performance. Now, there are EU directives in relation to contracts that are made over the internet. Can't recall exactly the reference for the directive, but even an exclusive jurisdiction clause is not definitive. But that's not the problem. It's actually enforcing the rights. So let's look at some of these examples. Booking.com. A Swedish consumer books a hotel room in London through the trader's website. When he arrives, he finds the room is infested with mould. Booking.com is a Dutch company. They say they are bound by only Dutch law, in spite of the performance taking place in the UK. So the question is it financially viable for the Swedish consumer to take legal action in the Netherlands regarding performance of a contract in the UK? That's $1 million question, and the answer in this case was no, it wasn't. Home and Away. A French citizen booked a home in the Canary Islands through the homeandaway.com website. They're based in London. The picture shown on the trader's website was completely different to the actual place. The consumer didn't like it and ended up staying somewhere else. The trader completely failed to respond to all the consumer's complaints. The consumer was out of pocket, I think, euro 1,000. I have another case which is the opposite end of the spectrum, where the consumer was out of pocket 18 euros. So it was a traveller who bought a ticket on Eurolines from London to Dunkirk. By a mistake of the coach company, the coach didn't actually go to Dunkirk. The consumer had to get off halfway at Calais and make her own way. Eurolines is based in France, part of the French Transdev group. Again, they failed to engage with the consumer weren't interested in the complaints, even though they were completely at fault. And by the way, failed to enter into any complaints process contrary to EU directives on travel. I have another example here, newstay.co.uk. It's the co.uk, which becomes relevant here. It's a well-known hotel booking site with a UK domain name. The consumer, who was from Scotland, booked a hotel in London. When she arrived at the hotel couldn't find details of the reservation made by the booking agent. And when she looked further, this is what the trader's terms and conditions said. You agree and hereby submit to the exclusive personal jurisdiction and venue any court of competent jurisdiction within the Kingdom of Denmark. So this lady had to take legal proceedings in Denmark. This is completely outrageous. The consumers of any redress could do nothing but complain to the hotel itself and not the booking agent who'd messed up. One more example, let's take Amazon. This is what they say in the terms and conditions. It's just mainly reiterate the point that we made earlier, which is that the consumer is only making an invitation to treat. So paragraph 1 of the conditions of sale, this is what it says: that the order confirmation email is acknowledgement that we have received your order and does not confirm acceptance of your offer to buy the products ordered. We only accept your offer and conclude the contract of sale for a product ordered by you when we dispatch the product to you and send an email confirmation to you that we've dispatched the product to you. So, okay, standing back, what does all this mean for the consumer? In the event of problems which can't be resolved by a payment transaction reversal by the credit or debit card company, the consumer is left with a no-win situation. It's a time-consuming, costly, even futile claim for compensation. In every case, it's probably going to be more expensive for the consumer to suffer the loss than to actually pursue the trader in the jurisdiction or the mechanism that we have currently available. So what's the big idea here? We won't allow contractual performance by the trader unless the offer made by the consumer, unless the invitation to treat is accepted by the trader on the consumer's terms. Now, consumers are not going to have their own terms and conditions, but what we can provide is we can bring to life a new concept of a universal charter of consumer rights. So in place of the usual or the normal traditional terms and conditions, we have a universal charter of consumer rights that will stand for the trader, for the consumer's terms and conditions. The invention, which is a lot more complicated, involves technology, unifies the consumer law process across the internet and provides a single or possible single global forum, which has not been possible until now. So what we have is we have technology which has made possible what lawmakers have not been able to achieve with such things as unilateral or EU directives or even national laws which are outdated. I hope this presentation has raised awareness about the issues with the internet. This is an issue which has to be grasped if e-commerce is to grow effectively. It's of fundamental importance to the socio-economic development of global commerce. I would like to hear from you if you'd like to learn more about e-commerce and our solution to the problem, or our own plans for the creation of a single global forum for the resolution of consumer disputes. Thank you for listening.